these in order, so that means State of Nevada versus Meta Platforms, pages 3 through 5, 886-110. So nobody else told me that they had a outstanding pro bono case, they could have jumped ahead. Okay, so let's give it a second, and remember on this case, 886-110, I'm gonna have you make your appearances in just one moment. Do you remember on this one, we do have a media request, and so they're welcome to record everything, other than if you tell me that there's an issue that's subject to your stipulated confidentiality agreement, please let me know that in advance, and then we will address that at that juncture and determine how to proceed, okay? I wasn't sure if you all knew that friendly reminder, since I think they're remote today versus being here in Florida. So can I have appearances, please? State of Nevada.
Good morning, Your Honor. Chris Turtzo for the state of Nevada, president of the courtroom, Mike Gayan from the Claggett and Sykes firm. Going through some of the appearances that I can see online. I also see Will Sykes and Katrina Stark from Claggett and Sykes, Raquel Fulgham from the Office of the State Attorney General, Phil Carlson from Nottawache Law Group, and Christian Barton from my firm. I apologize if there's others, but I think that covers the folks who are brought in and you can see on the screen, Your Honor.
Good morning, Your Honor. I feel special today moving up to this table. Dan Waite and my good friend and partner, Dan Bolsenberg.
And I feel special moving up to this part
There you go.
table. Good morning, Your Honor.
Of Womblebon Dickinson and Timothy Hester of Covington Burling for Meta Platforms.
Thank
And
you.
there are several other people that are on the screen remotely and in the courtroom, but none are making an appearance.
Okay, it looked like we still have an outstanding motion to associate document 303. Because somebody had requested that that be advanced and granted. Do any of you all see?
Is that Ms. Tesser
I am,
or is it Mr. Bush? I apologize, Your Honor.
one quick second, because when I mentioned that there's 300 and, well, over 300, I'm gonna need to click the 303 to go back. Do it, give it 1 second. It was Ms. Tesser. It was plaintiff state of Nevada's motion to associate counsel Dory Persky Tesser Esquire. You all done a hearing not requested, but please on these, please do the hearing requested, or send me a stip that the parties are non-opt, just because with large cases like this, we have to go looking to try and find it, particularly when I don't get a courtesy.
Understood, Your Honor. If possible, if we could advance that and grant it as unopposed, we'd appreciate that.
Let me check. Okay, so, yeah, that, like I said, wasn't set because of the hearing not requested. So the court finds, since that was filed back on 6/12/2022, there being no opposition and specific statements in open court was unopposed. Court had an ability already prior to today's hearing to review all the appropriate documentation was provided meets the Supreme Court rule. And so particularly Supreme Court Rule 42. You said did you say Mr.? Because it looked like it was a Ms. based on.
Ms. Tesser.
It's either Ms. Tesser or Mr. Bush. I couldn't recall which one
Okay,
that document.
sorry, Ms. Tesser's verified application for association counsel under Supreme Court Rule 42 is granted. It is so ordered, and so that gets taken care of. That means, of course, please provide an order under EDCR 7.21 to the DC 31 inbox. Okay, so you can feel free to sit down, stand up, whatever's comfortable, because remotely people are doing that. Nobody else is speaking, right? Anybody else who's remote is not speaking. Is that correct?
Correct.
Okay, so we don't need any audio visuals. That's fine. Okay, so you want a court's inclination?
Yes, Your Honor, that would be helpful.
Okay, so I have Meta Platforms motion for leave to file a post-hearing brief in opposition to the state of Nevada's motion for preliminary injunction. Document applies to messenger case. I'm saying that in light of, remember, we've got the 3 cases and we're focusing on each of them, or some are jointly. That's document 293, state of Nevada's opposition, 299, and reply 302. Before I give my inclination, I need a clarification point from what the court understands. Based on looking at the entirety of this lovely record, the court understands from prior pleadings in this case that the court's ruling on the injunction was to be nunc pro tunc to the date of the hearing. it wasn't to be from some future date. Is that the party's understanding, and the reason why I'm saying that, just to be clear, obviously, you're kind of doing your contemplating of what I might really be asking. Where I'm going with that is I might highlight certain arguments from when you all were here last about the injunction hearing being closed as of the date, right? The court citing two separate, various different provisions in your transcript, right? Okay, because remember we paused and I gave everyone an opportunity to look at the transcripts, etc. That everything was done as of that date. So the reason why the court is asking the question is because based on the way certain things are phrased, that was this court's understanding, and that was this court's statements at the last hearing. So is somebody contending that the court should be looking at it a different time frame versus the time the evidentiary hearing, and I would have had a ruling but for the request of the parties at that time back in 2024. And I don't want arguments. That's really a simple yes or no, okay? Because I appreciate you all are going to give me excellent oral arguments in just a moment, but I just want that point of clarification. Meta, go ahead.
Your Honor, our understanding was that the question of the resolution of the preliminary injunction motion was deferred until the resolution of all these other issues. So I wouldn't have thought of it as a non-pro-tunc. I would have thought of it as a pending motion that's still awaiting resolution at some point. After we get through, there was jurisdictional discovery. There's obviously been a lot of activity around the question of supplementing the record, but we had understood it was simply still a pending motion, but perhaps I'm not understanding the court's distinction about a non-pro-tunc issue.
Let me hear what the state of Nevada's position is, and then I might need to follow up for a point of clarification. Go ahead, counsel.
And the state's position would be the court's inclination that.
Mine really was a question at this point. I mean, I was quoting prior statements from you all at the last hearing, but so yes or no, you said it's as of that date. Okay. So to be clear what the court was asking, okay, is, well, let me go to my inclination. I'm really going to take it into account in my inclination. My inclination is to deny what has been filed as a motion to file a post-hearing brief in opposition to state of Nevada's motion for preliminary injunction. And one of the reasons why the court's inclined to deny it is because the attached proposed brief asks this court to change the nature of the underlying preliminary injunction, right? By changing the facts that says has occurred. Now, whether or not the rollout has or has not occurred, I'm only using this for purposes of my inclination. Please do not take it that it's for purposes of my actual ruling on the injunction matter. But you've asked this court, right? See the importance of a courtesy copy, because now I can go right to the page. Okay. You've asked this court by page 2 of your proposed brief, okay, at about line 18. You say, moreover, by continuing to pursue its motion for preliminary injunction, the state now seeks to overturn the status quo, not preserve it. When the state first filed this motion, Meta had just begun to roll out default E2EE Messenger and Facebook networks. This rollout is now essentially complete. The state's motion thus no longer seeks to stop Meta from implementing default E2EE, and instead seeks to affirmatively require Meta to remove this critical, and I'm not taking position, I'm reading it as is, okay? This critical safety and privacy protection for Nevada minors. The state now in effect requests a mandatory injunction reversing the status quo. That was when I was reading that only for purposes of what the potential motion was in the requested relief. It looked like Meta was saying that the state is now asking for a different type of injunction. And that's not what was presented to this court back in 2024 when I had the pleadings and I had the evidentiary hearing. So that leads to my reasoning, part of my reasoning on why the court is inclined to deny the request, because what it is not doing is it's not responding to the injunction that was actually before the court in 2024. It really is asking to supplement the record, which this court already ruled on at the last hearing when the state of Nevada asked this court over the objection of Meta, and the court denied the state of Nevada's request to supplement the record. And so this court would equally law the case, right? I've already ruled. Okay. You make sure you did your notice of entry of order. Am I gonna have a notice of? Nope, I do have the notice of entry of order. I thought I did as of Friday. Okay. Making sure I didn't have a Russ versus Clark County issue. So when the court looks at the way the actual brief is submitted to this court, it's not responding to what was actually presented to this court back at the time of the injunction hearing and when the court would have made its ruling, but for the request of the parties and subsequent aspects. But I could not find anywhere in the 200 plus entries since that time. Maybe it's not 200 plus because there's now 300 and whatever, but let's just say hundreds of entries since that time frame, that there was either a stipulation by the parties that somehow the nature of the injunctive relief would change by agreement of the parties. And so in light of that, I really do see this as supplementing the record, asking the court to rule on something different than what it was really sought to be asked back in 2024, leading to an inclination to deny it. Okay, caveat to my inclination. So does everyone at least understand what I'm saying? Whether you agree or disagree, you at least understand the reasoning why I asked the question. Okay. So caveat to my inclination. Caveat to my inclination is after reading this, and of course, having the benefit of the other week's extensive briefing and hearing on the motion to supplement, what I kind of am seeing both parties asking this court to do is that what you all would like to do is something that would be similar to oftentimes is done after a bench trial, where parties request to submit proposed findings of fact and conclusions of law, which reflect what actually occurred in the pleadings at that time and the hearing that happened, which then allows them to provide a reference point, yes, with appropriate authentication, right, from exhibits and or testimony of the witnesses. If that really is the request, the court would hear both parties' position on said request, because the court could see the merit of something like that, because okay. She was highlighting my very important points, right? Or being empathy for the fact when you all were here a couple of times ago and I had no voice. But sorry, okay, I can pause. Okay, I have cough drops. Okay. So. Reasons. Anyway, so I really was just saying I could potentially see the merit of that because of the. Now, this court is perfectly willing, perfectly able to go back to everything that was presented and go back and read it and do a ruling based on what was presented to this court in the actual preliminary injunction hearing. But once again, I'm appreciative that oftentimes experienced counsel asks for some kind of, and I'm calling it findings, facts, and conclusions and law. There's no way that I'm confusing Rule 56 standard or bench trial standard. I'm really just trying to pick a document that happens most often, right? But that would potentially allow each of the parties to do what is, well, from the last hearing and this hearing seems to potentially be what the parties are wanting to do, and allows you all to summarize. And I'm treating this as summary. It's not a new argument, right? It summarizes what has been presented and then doing the determination. So enough of me speaking. Let me hear what you all want to do. It's your motion. Go ahead, please.
Thank you, Your Honor.
Remember, nobody asked for special settings. That's 5 minutes each side. Not
Yes, I understand. I'll be quick, Your Honor. First on the court's last question about proposed findings and conclusions, we would favor that. We think it was a long hearing. It was over a year ago. We think it's beneficial. We believe it's in the court's discretion, obviously, but we think it would be beneficial for the parties to be able to explain what they believe the evidence established. Obviously, all of the briefing that was submitted was before that evidence was given. We think it would be useful for us to be able to explain from our vantage point what we thought we developed in the evidence. So we would favor proposed findings and conclusions if the court is open to that. On the first point the court raised about whether we're asking the court to change the facts, I think in relation to a requested injunction, it seems to me inherently necessary for the court to take account of the passage of time. there has been over a year's time that's passed. There was evidence presented at the hearing that the rollout of end-to-end encryption would take a few months. So we're not adding new facts. We're drawing the inherent conclusion from the facts presented at the hearing. But regardless of whether it's characterized as adding new facts or whether it's simply drawing an inference, a necessary inference from the testimony already given, it seems to me the court is being asked to exercise its equitable power. And the fact that a year's time has passed and things have changed needs somehow to be taken into account. Things have not stayed the same over this past year. And so there needs to be some opportunity to address that. I think it's clear from the testimony already given that the rollout is finished, essentially, more or less finished. And therefore, it does change what the state is asking for, or putting it another way, a non-pro-tunc order addressing an injunction requested in February or March 2024 would be at odds with what has happened since. And somehow the court needs to be taking that into account. We submit in relation to exercising its equitable authority. So our view has been that we were asking for something different from what the state asked, because we were simply drawing an inference from what was stated as testimony last March in the testimony before the court. We weren't adding new facts. We were simply pointing out what the inherent conclusion is from the facts as given. But whether that's adding new facts or whether it's simply taking account of the record as presented to the court last year, we think it would be necessary for any injunction to take account of how circumstances have changed since the state first moved for the injunctive relief it seeks.
Okay. Let me walk that through a couple of different ways, just to get a better clarity of what you're proposing is. Sometimes it happens, right? The parties ask the court to defer a ruling, okay. Recently, I had a summary judgment ruling that maybe I've got it later on, possibly later on today, where they wanted it to be held in abeyance because they potentially wanted to engage in settlement negotiations, right? And then it was just a matter of whether pen to paper had already occurred and it just hadn't been published. Okay, actually, one of the counsel that was recently here. Okay, I was in the middle of my oral pronouncement and people said, wait a second, Your Honor, we don't want you to finalize that because we want to see if we can try and resolve a case, right? But so that's just all done, taken care of, but just not memorialized in writing or not fully articulated, but it wouldn't change. Nobody's doing new briefing. No standards have changed. No additional pleadings would be filed. Okay, that's this court's, based on what's happened since and ruling I just made, is where this case in this ruling would be, right? It would be as if potentially I had drafted everything I already have, okay, on that date, right? And just reading it out loud, right? But it seems in your request, you're really changing the nature of the relief sought by counsel as distinct. Remember the carve out in my ruling of the last week that, of course, new case law, the court, to the extent it is applicable, needs to take into account, but that's I don't like file a reconsideration. I'd have to do it I'd be doing it anyway. But you're asking this court, at least in the section I read, right? Because it seemed on the plain language, to change the nature of the actual injunctive relief, which is, body of law is sometimes distinct when you're looking at the nature of the type of injunction, right? And the standards set forth. So how do you reconcile that that's what your title is, right? Your title is a post-hearing brief in opposition to the state, right? Which could be everything's done, taken care of, and then regardless of when you file it, right? It just as if you had filed it that same day as the last testimony was taken versus it appears you're And I'm repeating myself a little bit just to be, so that you phrasing a little bit different ways to make sure I'm being very clear. Versus what it appears is you're asking this court to really change the legal relief that was being requested.
I think the passage of time has to be taken into account in evaluating the question of injunctive relief. We're obviously not ourselves asking for an injunction, but our point is passage of time is one of the factors that bears on the nature of the equitable relief the court should be willing to grant. At this point, for instance, the state has taken over a year to get things resolved. The state
or the
asked for the
parties,
jurisdictional discovery. The state we were prepared on the papers to have the court rule on the jurisdictional discovery. The state asked for jurisdictional discovery, but whoever could be assigned responsibility for the time has passed.
I'm going to pause you for one quick second, because in fairness, folks, you all have a lot of stipulations in this case to extend the time, right? I mean.
No, I understand your argument.
Let's with the time component, right? It's not a one side or the other. I'm really trying to focus on the way your brief is phrased, right? In its titling, is it sounds like, well, guess what? We're just going to do what was there that day, and we'd like to just provide a brief that summarizes everything until you actually read your brief. And this is neither negative nor positive, but your brief does clearly say, Your Honor, you should be treating this like a different type of injunction than what was before you in 2024. I'm trying to reconcile that with what is in the best needs of this case, what there's agreed to by the parties or maybe not agreed to by the parties, and the applicable case law. So it looked to me like you're almost saying I should hold another evidentiary hearing to kind of determine if I should be looking at a different type of injunction, but it was their injunction. So you can appreciate there's some questions this court has.
I take the court's point. I'm not trying to figure out where the delay came from, but the fact of the delay, the fact that we're over a year later, seems to me a crucial factor for the court to take into account, both in relation to the fact that the rollout is essentially complete, in relation to the delay and whether there's really a basis for an injunction when there's been this nature of delay. Years have passed since the announcement was made that Meta was going to do this, et cetera. So the delay, it seems to me, has to be taken into account. We had understood that this request for injunction was just pending and needs to be resolved. But one element of the resolution of that injunction is the timing, how long it's taken. When it's taken this long and the rollout is essentially complete, it's not that we're converting the nature of the injunctive relief. It changes the standards that the court needs to apply in making its determination. The legal question has changed by the passage of time. Now, I view that as somewhat separate from the question of whether we're entitled to file a supplemental brief, but the real point is the passage of time bears centrally on the question before the court as to whether it should grant the injunctive relief.
Okay, appreciate
Thank
it.
you, Your
Thanks so much. State of Nevada, whoever's taking that, go ahead, please.
Is it okay if I stay here, Your
You
Honor?
can sit down, stand up, be at council table, be at the podium, whatever you'd like.
Got an organizational system over here. Couple things, Your Honor. In terms of reconciliation, I don't see how Meta can reconcile the position that they now appear to be taking with what they argued a couple of weeks ago, that the record was closed, that no more evidence could be added in order to oppose the state's motion to supplement the record. Again, and I didn't argue that hearing. I did watch the entire proceeding, but to add materials that were in large part developed or obtained during jurisdictional discovery, the Meta argued that the record's closed, nothing can be added. And what they were seeking leave to do with this brief was essentially provide a closing argument, connect the dots of what the evidence at the hearing and how that applied to the request that was made in the brief that had been submitted. Now we're hearing the passage of time justifies, I think in answering the court's question, another evidentiary hearing. There's no evidence that they've supplied about what they've chosen to do while they believe this injunction was pending. And that's really all that it is. What actions do they choose to take or not take after the March 21 hearing? And again, the Meta's already argued that the record should be closed in terms of evidence. So to the extent what they're requesting is for to provide some sort of a brief about how new things have happened during the passage of time, I think that's diametrically opposed to the position that they took and this court agreed with when it denied the state's motion to supplement, Your Honor. So it's different from what they claim. And then if we take the request as to how I understood it and the state understood it to be framed when it was filed was for a summation. Well, Your Honor, again, just to highlight some of the things the court found the last time we were here, the parties filed 2 briefs each leading up to the evidentiary hearing. They had 2 days of evidentiary hearing, went overtime with the court and the court staff's indulgence. And then the court asked the parties, do you want a summation? The parties both gave summations. At that point, I didn't see a request for a closing argument brief. As the court pointed out as well, up until the April stipulation this year, there was no stipulations for closing briefs. This motion was filed just a couple weeks ago. And again, Meta's taken the position that the evidentiary record's closed to the extent, and that position was essentially adopted. The court denied the state's motion to supplement, and the entire proceeding in the state's perspective should be closed. This court indicated it had what it needed to rule on the injunction, subject to first determining whether personal jurisdiction was appropriate such that a valid injunction could be issued. The state's position is that these proceedings should all be closed, that the request for supplemental briefing should be denied. Of course, if the court wants something, the state is happy to comply. In response to the court's earlier indication, if the court would like something, the state will of course comply. But from the state's perspective, these proceedings should be closed. The request for a supplemental brief, again, is frankly now Meta taking a position that seems very different from the one they took 2 weeks ago when it helped them to defeat the state's request to add evidence to the record. So I think the request should be denied in its entirety. Unless the court wants something else, the proceedings on the injunctive relief request should be closed and the court can issue its order.
As Meta articulated, right, from their position, the passage, you all agree the passage, this is 2025, not 2024. Everyone agrees on that part, right?
Agreed, Your Honor.
Yes.
Okay, there we go. Okay. Both do? Wow. Okay, so I got that agreement. It's 2025. Okay. So from the state's perspective, is the court, you're asking the court to rule on a preliminary injunction based on everything that was filed prior to the evidentiary hearing and the testimony of the evidentiary hearing, and not taking into account it's 2025 versus 2024 at the date that the court will be making the ruling?
Yes.
Okay. So how do you respond to what counsel for Meta has articulated, that the court has to look at the passage of time and what actually is the status, right? And if you're walking it through, okay, so in the court's mind, I try and explain what I'm thinking, whether you agree or disagree with it, is, right, you look at the standards for an injunction, right? And so if you're looking at the, right, how would you balance some of the prongs of the injunction standard? I don't want the long version. I'm taking this as the hypothetical. If you were the court looking at making a ruling, right, do I say as of what was presented to the court as of the date of the hearing, the irreparable harm, and I know you all would like me to fill in that blank different ways, but let's just say the irreparable harm is, met, not met, or are you saying, that's why I asked it as a non-pro-tunc, because I would have to be looking at as writing the order in 2024, or are you saying that the court should be taking into account what that is now 2025 or something different? I'm not limiting you to those 2 options. You understand the challenge. I mean, put yourself in in drafting said order in 2025 for information provided in 2024, which is why the court A asked the clarification question at the very beginning, and B gave us a little caveat on an inclination, because there I really saw that it gave each side the opportunity to address not only what was specifically presented, but how they view that the court's analysis on the prongs on an injunction should be addressed. I really just thought it was fair to both sides to give you in a summation concept, not a new concept, not changing things. Or maybe you're saying I should revisit my ruling of the other week and I should be supplementing on both sides. One side gets to argue it's not really an injunction anymore on the basis that was before me, and the other side wants to bring in a whole bunch of new arguments and things like that. I'm not opening that up. Everybody who's patiently waiting for their cases would not be happy with me if I went into that, and it's way past your 5 minutes, right? But I'm just trying to get a sense here of what the party's position is, and don't take my asking these questions if the court hasn't already reviewed applicable case law. I'm hearing what you each have to say. Go ahead.
Okay, to try and address the.
Putting yourselves in the role of the judge trying to write draft that ruling.
Understood. And so a couple things to try and take the last question first. I do think there seems like a bit of unfairness in denying the state's request to supplement the evidentiary record and then allow Meta to say, well, during the passage of time, actions have been taken, which would necessarily constitute new evidence that needs to be taken into account in the way the injunction is framed or what the state is asking for. Recognizing that both parties.
That's why you heard the court's inclination. Go ahead.
Indeed. And so the state agrees with that inclination. In terms of, in addition, Your Honor, this has been going on a long time. Both parties did enter in stipulations throughout the process. Meta did pursue several motions to dismiss, which I think have impacted the adjudication of this proceeding. And ultimately, I think from the state's perspective, again, the proceeding should be closed. If what the court is asking for is there an impact on the passage of time on the injunction, I think that's a completely separate issue than what Meta has proposed to file a brief about, right? This brief doesn't really focus on that. It does a lot of things. It's a summation brief. If it's a narrow question that the court wants answered on, is there something that has changed? Again, we don't really, even from the state's perspective, have evidence on that. We have Meta arguing, they claim the implication from the testimony at the hearing is that the ED rollout's completed. The state doesn't know what that evidence really is, right? If we're going to go down that road, I don't see how the court does it without another evidentiary hearing, and which is simply going to result in more delay and defeat the purpose of the injunction as it's already been sought. I think where we are at this point and all of the time it's taken us to get here means and mitigates, the Meta's request. If they want to seek to try and dissolve some injunction the court issues because they think the passage of time means it's no longer relevant, that's an option that they can pursue. But in this particular case, I don't see that Meta has put forth any evidence indicating that the state's request has been mooted or any compelling evidence to indicate that the state ought to be required to present anything further in order to obtain the injunctive relief that it sought. The state's briefed it. It's gone through an evidentiary hearing. It's gone through jurisdictional discovery. It's fended off, I think, 2 motions to dismiss. And with the think at this point, the state's entitled to obtain a ruling on the request for injunctive relief based on the record and the briefing as it stands.
Okay, here's my pausing question. You all can appreciate we're way past 5 minutes. I've got a lot of people. Seems to me that you all might want to speak among yourselves, and that maybe I recall this case in about 20 minutes or so, half hour, and go through some of the rest of my docket. So, well, if anybody wants to think this through, or do you want me to rule right now? I'm just trying to, because realistically, I'm not going to have time to address a different issue that's not on for today, which I'm gonna have to set for hearing, which is your 53 request. And I'm gonna have to address that it doesn't include a 16.1 F request, and I don't know if you've done an ECC. There's some other issues I've got to address with y'all. Okay, not to be saying a whole bunch of numbers out there, but does it maybe make sense to give you all some time to talk in the hall so people aren't having to worry about doing little notes and whispering back and forth, and to kind of think through what each party's position are and recall this about a half hour and get through some of my rest of my docket. If you all say no, then you'll hear a ruling right now.
I think the state's ready for a ruling, Your Honor.
If either side's requesting, you know, I'm gonna give it some time, right? Because that's the fair thing to do. Do you want a ruling right now? You want? Should we call you?
Your Honor, we're prepared to have a ruling now if the court is ready to rule.
Okay. And the state, you do not want to do a findings of fact and conclusions of law, an opportunity to do that, is that correct?
It's correct.
Okay, well. Here's what the court's gonna do. The court is going to grant as modified the request for post-hearing brief for both sides, because I saw it in your opposition, the state also made a request as an alternative relief, so, which is what's leading to, I'm gonna give you all both the opportunity to do findings of fact, conclusions of law. I am not going to accept the brief as done, because the brief as done, I really do not find is quote a summation post-hearing brief. It's raising new issues. I'm not gonna repeat myself. I already read to part of page 2. I could read other sections, but that was the cleanest, easiest one. So to the extent to take into account the actual document that was attached, that is denied. However, since both the motion and the opposition for the alternative relief, that basically the state also asked in their opposition that they want an opportunity to do a quote post-hearing brief, we're going to make it a quote post-hearing brief. And the way I'm going to phrase it is, I'm viewing a quote summation post-hearing brief is findings, fact, conclusions of law, which each side, without bringing in anything from a new evidence, can provide. And I'm going to give you a deadline, or I'm going to ask y'all to give me a letter by Friday, whichever you want. And you're going to have the same date. And if you choose not to do it, that's fine. But I'm going to give each side the opportunity to do it. That way I'm not requiring the state to do it if they don't want to. But I'm also taking into account that that was an alternative relief request in the opposition. And it allows each side to do, quote, the summary. So you can cite the testimony that was presented to the courts. You can cite the exhibits. You can cite the case law that was previously presented. You can also cite if there is a new case, because remember, I'm being consistent with my ruling of a couple weeks ago, to the extent that there is a new case that a party feels on point that applies to what was actually presented to this court back in 2024, then that can be cited. No new arguments, no new positions, no new scope of what this court needs to do or not do, because that would fall outside of the actual motion before me, which is a summation post-hearing brief, right? And it would fall outside of the alternative relief request, excuse me, that was stated in the opposition, okay? And I think that that would allow each of the parties to doing that and not requiring either party to doing it, but giving you a date certain by which they need to be submitted. Does not have anybody incur any additional expenses, but gives everyone an opportunity to provide that and to highlight things that they think for purposes of what happened in 2024 to get you a ruling. It's also consistent with some of your other stipulations on right efficiency, et cetera. So that's the court's ruling. It is so ordered. That means it's your motion, which means you draft the order, UDCR 7.21, circulate it to the opposing side, provide it back to the court in accordance with the administrative order. Now, would you all like to provide this court a letter by Friday on what dates you would like to have that so you can consult your respective schedules? Or would you like me to give you a date right now, like maybe next week?
We'll take door number 1, Your Honor, and we'll
wouldn't be
confer
that-
and submit the letter by.
You understand, it would not have been next week unless you all. Okay, but remember, if you're asking for a very quick ruling, then consistent therewith, I'm going to have to give you a short deadline because, right, my rulings are based on things presented to me, so.
We can probably go out in the hall and discuss the date and send the letter fairly quickly. I do want to.
By Friday, is that Friday works for everybody?
Yes, sir.
Or sooner, yeah.
Okay, or so I'm giving you no later than Friday. I don't know what your schedules are. Okay, I'm also going to tell you that you're going to get a notification from this court, and I am perfectly fine if it's remote appearances. We need to discuss your stipulation. I am not going to hold everybody that's currently waiting to have their motions heard, right? to go through that, but there are concerns with your proposed stipulation, including the fact that it did not, and maybe you don't want a 16.1F request, but please don't tell it to me orally. I'm just saying, I need to go through a lot of the different things, because I will tell you this court's inclination is going to be consistent with some other cases that you all are aware of, where this court is going to talk to you all about a trial date before I do a 53, so that we make sure that the discovery issue doesn't de facto mess with trial dates, okay? And of course, we didn't send you for a Rule 16 conference because we don't have a JCCR. Yes, I'm appreciative the 30 days has passed, and maybe you all were thinking maybe there's a reason why on the 13th, the potentially almost last of the 30th day before an ECC would have been due, why I got
No,
the proposed stipulation, but it doesn't have a 16.1F. But I think this court is going to deem my hearing for next week. I'm going to evaluate it at that time. I'm not going to find anyone non-compliant between now and then. Does that meet everybody's needs?
Yes, Your Honor, and not to get into it for the state, but the parties have held an ECC. We've been meeting and conferring.
Okay, are you planning on doing 16.1 disclosures or?
Those are done.
Those
We're
were
just-
made last Friday, I believe.
We're just in the process of JCCR.
Oh,
So-
okay. I wasn't sure if you were gonna, okay, because, so then,
And we've been communicating with ARM and Judge Gonzalez.
okay,
Very
then I'm gonna,
pleased, but
since that wasn't clear in your,
We're happy to talk about that when the court has time.
right, but now I'm just trying to real quickly decide if I should wait for Rule 16 conference, because you're gonna want me to sign this beforehand, but I'm gonna need some clarity before I sign it, because there's some other issues too.
A status hearing or whatever to address your questions, Your Honor, probably sooner than later, but Mr. Gayan is correct. We have had the ECC.
Okay.
We did do initial disclosures, both sides.
Okay, yeah, it wasn't in the proposed, you had one reference, 16, but you bundled it with a 53 and a 45, and I didn't see a specific request, and so I wasn't sure what you all were requesting. Okay.
Should we confer on whether we want a 16.1F designation, and if the parties want to resubmit, is that something the court was wanting to? must
There's
resolve?
more questions realistically that I do have.
Okay.
In order to meet the needs, particularly since you have 3 consolidated cases and how you're potentially going, you know what I mean? So we do need to walk through that. That's why I just thought if I said a status check, everyone can appear remotely for anybody nobody feels compelled to fly into town, drive into town or whatever into town. Seemed to meet everybody's needs. If I did it next week, it seemed to balance the timing so that you can move forward with what you need to move forward with. But since you couldn't move, since I had to know the 16.1 answer next week and Tuesday or Thursday, just 26th or 24th. I happen to know what next week's dates are.
The 26th is better for me. I have a hearing with Judge Gall on the 24th, but there's plenty of lawyers for the state, so that doesn't need to come.
26 is better for me as well.
Okay,
But I'll be back at the little kids table.
the third answer is, it looks to me like you're getting me the joint letter before Friday anyway, and you're not waiting till Friday. Just tell me which date you think a status check makes more sense, okay? And if we can accommodate, we will, okay?
Thank you, Your Honor.
Thank you so much, everyone. Okay,
Thank you, Your Honor. Good morning.
appreciate it. Good morning, have a good one.